Thanks so much. It's my pleasure to give this presentation. This is a wonderful program put on by the Bureau. I think it's much needed, and I hope you all find it as helpful. Let me start with a caveat. My presentation here today isn't meant to discourage your fundraising efforts in Michigan or otherwise. People every day in the state of Michigan are very successful raising money and staying out of trouble. Today's presentation is really to provide you with a grounding, if you will, sort of a basic understanding of the landscape so that you'll know when you need to ask questions and have some idea about what the overall or overarching requirements are with respect to the federal and state securities laws in an effort for you to be able to navigate through what is really generally understood to be a complex and highly regulated area of the law. Let me first indicate to you that perhaps the best way to stay out of trouble when you're, you know what, I'm having trouble moving the screen. Tyler, could you make sure that I'm enabled to? Thank you. In any event, Tyler, maybe you can move to the next screen because my controls aren't working. Thank you. So the first thing I would like to indicate to you is that, and I know it's a lawyer telling you to don't hesitate to contact lawyers, but the truth of the matter is that the securities laws are extremely complex, and it's really not intuitive. This is not driving a car, and I know logic lots of times helps you understand what the rules will be in driving a car. Unfortunately, the securities laws are not intuitive. There are many basic concepts that don't seem to follow common sense, and that is because of the complexity and sophistication of this area of law. So don't hesitate to take that ounce of prevention to avoid that pound of cure if necessary. There are steep penalties in the securities area. Not only are there civil remedies, but there are also criminal penalties and sanctions. And the civil causes of action in this area are more than just having to give back the money to the investor or what the investor lost. In many cases, the investor will be permitted to get what we call consequential damages or benefit of the bargain damages. These are damages that were the expectation of what the investor thought they would get or what they were promised and didn't get, not just what they put in and lost. Also, consequential damages can mean that the fact that they were deprived the money might have other ramifications for them that you'll be responsible for. Also, the statutes provide for attorney's fees and interest. So given the steep legal landscape and sanctions, it's always best to, if you have questions or uncertainty, to seek out professional advice. I thought the best way to orient you and to really arm you with respect to understanding the regulatory landscape is to provide you a basic explanation of what the laws and regulations look like. I want to start on the federal side because much of what you do, even though it's in the state of Michigan and Michigan law and regulatory law may apply, federal law is likely to apply too. There are two statutes that are the grounding principles for really the regulatory scheme in the United States, both state and federal. It's the 1933 Act, the Federal Securities Act of 1933, and the Federal Securities and Exchange Act of 1934. And I think it's important for you to have a flavor of that because the regulatory scheme and what you'll be navigating through is established by those two acts. The 33 Act deals with the issuing and selling based upon the issuance of securities. This really applies to the entity issuing the shares. And there's two aspects that are important with respect to the entity issuing the shares. Do the shares need to be registered, or are they exempt from registration? Do they fit under an exemption? And the adequacy of their disclosures. So registration and disclosure with respect to the issuing of shares is the important aspect of the 33 Act. The 34 Act, the Securities and Exchange Act, deals with the exchange of shares. And there's three aspects to the 34 Act that greatly shape the securities law. The first is what public companies have to disclose. Your annual reports, your proxy statements, all those kinds of things are regulations and then, statutes and then regulations promulgated under the statutes that fall from the 34 Act. What your disclosures are, what your reporting requirements are. More particular to you, it also concerns the trading of shares and who can sell shares, who can trade shares. The third aspect of the 34 Act is it creates the SEC, the Securities and Exchange Commission, and makes it the chief regulator of the federal securities laws. With respect to the trading of securities, which you're probably most interested in, there's one aspect that is about the markets, what the markets look like, how they conduct themselves, and so forth. But for yourselves, the other aspect is who can engage in the sale of securities and how those who are engaging in the sales of securities can do so properly. And just like the companies who are issuing the shares, do the shares have to be registered? The same goes with the individuals under the 34 Act. Do the individuals need to be registered? And of course, there's disclosure requirements for them. For you to have an understanding of that aspect, it's helpful for you to understand who the regulators are on the federal level, so you'll understand who the players are and how they fit in to what you're trying to do. So the 34 Act makes the FCC, the top cop, if you will, with respect to the sale of securities in the United States. Under the Securities and Exchange Commission is what they call self-regulatory organizations. You may know them as the New York Stock Exchange or FINRA, the Financial Regulatory Authority. Those are sanctioned by the SEC, approved by the SEC, set into the rules and regulations that the SEC require for self-regulatory organizations. The self-regulatory organizations then have what they call member firms, member broker-dealers. Merrill Lynch, Raymond James, you name them. Those firms become members of FINRA or the New York Stock Exchange or both. So you have the top, the SEC, then you have self-regulatory organizations, then you have member firms as the third round, and the final rung is what we call associated persons. Those are the individuals who sell securities, who have to be registered and be associated with a member firm, right? Member firm has to belong to SRO or self-regulatory organization who has been approved by and regulated by the SEC. So that's how everybody fits in. So to the extent that you hear about the commission, you hear about FINRA being a regulator on the federal side, it's because of this regulatory scheme that the Act developed, and that people who want, an individual who wants to sell securities, who needs to be registered, has to belong to a member firm. On the state level, those two principles, registration of securities or individuals, disclosures associated with securities, and the sale of securities, are part of the Michigan Securities Act. And so you may not need to register federally, but you might need to register under the state offerings. You might need to register under the state with respect to the sale of securities. Both at the federal level and at the state level, there are three aspects to the regulatory function. There is the Bureau inspects, inspects broker-dealers, inspects entities that sell securities. It investigates, has investigatory power to find out and discover if there's a violation. And then they have enforcement individuals who can do the enforcement. So that's, if you will, the regulatory landscape. Let's start off first with registration and the issue of registration of the interest being sold. And as it says here, Michigan law makes it unlawful for any person to offer or sell any security in the state unless it is registered under the Act, that's the Michigan Uniform Securities Act, or the security or transaction is exempt from registration. And there's various exemptions to registration. And when you go to, if you're going to issue securities, you'll want to consult with an expert as to whether or not you can fit into an exemption from registration. There are certain kinds of private offerings. You may be familiar on the federal side of something called a Regulation D offering. That's an offering that's to accredited investors, to a limited number of people who have a certain worth, have a worth. Those don't have to be registered nationally or the traditional registration process. So the interest being sold needs to be registered or needs to be exempt from registration. And the same is true with respect to the individual. An individual or entity involved in the solicitation or sale of security either has to register or be exempt from registration. Now, what is a security? And I know many entrepreneurs would like to say to avoid registration in the registration process. And they come up with money-raising methods that they hope, based upon their sort of application of logic and common sense, would say that it's not a security. The most common that we see is people who have notes or some kind of borrowing mechanism. So instead of someone making an investment and buying an interest, they loan the money and they get a note back, and then that money is used, or those funds are used for investment purposes, and they get interest based upon whatever's negotiated in the note. That is likely to be considered a security under the federal and state securities laws. The definition of securities is extremely broad, and I have here some examples from the statutes about when a note or an evidence in evidence is a security, and you can see that these are finite types of transactions, which generally are not in the fundraising area. Consumer financing, mortgages on a home, short-term notes secured by assignment of accounts receivable. These are more traditional types of loaning practices. Otherwise, it'll be considered a security. So again, when you're forming or deciding how you want to raise money, and you're hoping to avoid registration because what you're selling is not a security, it's wise for you to consult with an expert. Exemptions to registration. As I mentioned, both state and federal acts have various exemptions for registration. However, most of the exemptions have requirements to fulfill. The fact that you're under an exemption doesn't mean that it's not regulated. For instance, we were talking about Regulation D. There are certain disclosure requirements in the memorandum. There are certain subscription agreements that you have to comply with the regulation. And you can only sell to a certain kind of investor. And you have to be able to document that investor, the accredited investor, fulfills the requirements of the exemption. Failure to register shares that should be registered can subject you to civil and criminal liability for selling unregistered securities. The civil liability can be twofold. One, it can be an enforcement action from the state level or the federal level, but it also can be the individual within a certain time frame, depending on whether it's a federal or state action. The individual can just say, I don't want this security anymore. You didn't register it. It should have been registered. I want my money back. And, oh, by the way, under the statute, I get interest and I get attorney's fees. So you essentially, if you don't register, you're giving the investors a put to get their money back plus. With respect to criminal liability, there are criminal statutes. These are typically exercised when there's not necessarily a technical violation, but a scheme or an abusive situation with respect to investors. One of the misnomers that is really a common mistake and an understandable mistake, but one that the regulators are unforgiving about and the law is unforgiving about, is the fact that you're offering an exempt from registration does not mean that the offering is not subject to the disclosure obligations of the statute or the common law. So the fair disclosure applies to almost any sale of securities, whether it's exempt or not. So your disclosures have to have material facts, which cannot be misleading or cannot be incomplete so as to be misleading. If you want to, that really is the sort of the simple principle. Is it misleading? Are these material facts, are they important to a reasonable investor? And are they fairly disclosed to them? Or is it incomplete? Are you leaving out something so it's misleading to the investor? Improper disclosures, which are the most common type of securities claim in this area, will subject you to, again, civil or criminal liability. And the civil claims by investors and by regulators are not simply giving the money back, as I indicated before, but can be damages beyond that in attorney's fees and interest. So again, it's important for you to be as careful as you can with respect to your disclosures. I would say the technical aspect of registration aside, how you disclose things is clearly the most important aspect to your complying with the securities laws. Also, it is when there's a criminal prosecution for a securities transaction, it's highly regular that it's because of improper disclosure. With respect to an individual, does an individual or an entity who's involved in the solicitation or the sale of an interest need to be registered? And if you want a sort of short rule of thumb, if you will, as to whether or not you should be thinking about either yourself or people you're working with who are selling the securities or raising the money need to be registered, the issue is, are they getting commission or compensation based upon the consummation of the sale? Typically, if you're paying a percentage of when a transaction closes in the sale of securities, the individual will likely need to be registered unless there is an exemption to that, and it would be a very narrow exemption if you're paying commissions. The receiving of commissions or compensation based upon the closure is the hallmark for registration, according to both the Commission and the state of Michigan. Failure to register as a securities associated person can, again, subject you to civil and possibly criminal charges. The civil claims can be made by investor. And in the same way that failure to register your security gives the investor a put, if you will, to get their money back, get interest in attorney's fees, the same is true with the failure to the individual to register. So you could have a situation where you register your security or you get a proper exemption, but the people who are selling them also needed to be registered, and they aren't registered so the investor can put the investment back to you. And I think this is a particularly difficult area for entrepreneurs, particularly those starting out, because I know you're trying to save money. You need to worry about the bottom line. So, again, an ounce of prevention is worth a pound of cure here. If you take some time to consult with an expert or deal with people who have experience in successfully fundraising, it'll be very helpful for you. I want to talk about some best practices and how to avoid staying out of trouble while raising money. The first is documentation. Documentation is extremely important for you to prevent or to help minimize the risk in your fundraising. Document, if you have an accredited investor, document the fact that you've had a discussion with them and this is what they've told you, and throw it in a file. If you have any kind of significant discussion that could later be questioned or pose a risk, if you document the discussion in an email, confirming email, anything like that, that's extremely important. It's also important that your documentation be correct. Not just simply accurate, but being the kind of record that you want to have. Should there ever be an issue, that you would feel comfortable showing as part of a record in God forbid, a court case. All too often, emails are too informal. They don't mean exactly what the individual had wanted to say, or it's too colloquial, if you will, or informal, and it looks bad in hindsight. So your documentation that surrounds your fundraising, either your internal documentation as you communicate with your others in writing, or with respect to the investors, to the extent that you're having significant meetings and that are oral, it's good to document that, yes, I discussed this with this individual, and yes, we talked about this particular situation. Documentation and records, record maintaining is very important in many areas, but let me give you an example. If you have projections of any kind or a business plan with projections of any kind, the backup for that is something you should retain in your files. It shouldn't look in hindsight like you just sort of made it up out of nowhere because you cannot find what you were relying on in order to make the projection. Maybe you were relying on a study about your area of business that was by a consumers group or by Google or by somebody else, and you had very legitimate source, but you didn't maintain it. You didn't print it out or you didn't download it and maintain it. It's important for you to maintain records about your key information, your key material facts. Those kinds of things that people would be particularly important to people. Also, it's important to maintain them and be able to find them. Put them in a spot that so you can find them easily. And if they're kept electronically, make sure that you've backed them up. It's also important for you to think about your corporate formalities. Make sure that the entity that's raising the money is a proper entity, that you keep up the formalities of that entity. You have the proper officers, you have the proper documentation, you have the proper bylaws. This is not necessarily an antidote to save you from all kinds of personal liability, because both on the state and federal level, there can be individual liability. On the civil side and criminal side for certain violations of the securities laws, but it's a good practice, and it's a good practice for most legitimate business to follow. It also helps you in your whole fundraising aspect, to the extent that people are doing due diligence with respect to your entity and so forth. The fact that you're properly registered with the state of Michigan or wherever your entity is filed, it will be important for those who do due diligence, and the quality of your record keeping with respect to your entity will be important to those individuals who are interested in seeking your products or whatever it is that you're trying to sell to the public. And with that, any questions?
Okay, I don't see any questions at this moment. If there are any, could someone please get them in? Nope. That was a very, very thorough presentation. Nope, no questions, so I think we can go ahead and go on. Thank you very much for joining the fifth of our 6th Lunch and Learn webinars. We hope you all enjoyed it, and we want to thank Mr. Henney for taking time out of his busy schedule to share some very important information with us. I want to remind everyone that a recorded version of this webinar will be available for viewing in the near future. Our next webinar is scheduled for May 18th, and the topic will be crowdfunding. And one last reminder that our next upcoming live seminar will be in Grand Rapids on May 17th if you would like to sign up. Once again, the seminar is free and breakfast and lunch are included. Thank you all for joining us, and thank you, Mr. Henney, for doing this presentation again very much. We really appreciate it. Thank you and have a nice day. Oh, wait, we have 2 questions that just came in. Are you still there, Ray?
I am, thank you.
Okay, they always come in at the last minute. Okay, we have a question that says, what about a very small amount of sale of stock, like $10,000?
There are exemptions.
So.
Yeah, no, I understand. Okay, so there's 2 aspects to that. Will that have to be registered? Probably not. That doesn't mean you may not need to notify the state depending on how you sell the stock. If it's 10,000 shares that you're selling to family and friends, it's likely an exemption. You'll be able to fit into an exemption from having to register it. You still might have to give notice to the state depending on the circumstances. But notice is just a form, a one-page form that you can get from the website, the Michigan Securities Bureau website.
Okay, thank you. And the other question, believe it or not, was just a compliment. It said, thank you very much. This was very helpful. So.
Oh, okay, great. Thank you.
Okay, I think that's all. If we do get any questions at the conclusion or continue to get any, we will go ahead and email Mr. Henney those questions, and I'm sure he'd be happy to respond to those.
My pleasure.
Okay. Thank you very much for joining us. Thank you very much.
Take care.
Have a good day, everyone.